Yes, good morning, Miss Gallagher.
Good morning, my lord, my ladies. I act with Mr. Jude Bunting, Queen's Counsel, who sits to my left, in this matter for the Appellant, Guardian News and Media. Mr. Jonathan Crowe, Queen's Counsel, and Mr. Adam Speaker, Queen's Counsel, appear for the first respondent, the Executor of His Royal Highness the Prince Phillip, Duke of Edinburgh, deceased. Sir James Eadie, Queen's Counsel, and Mr. William Henderson appear for the second respondent, the Attorney General. May I just deal at the outset with a number of brief housekeeping matters. There are limited papers. For those of you working from hard copy bundles, there are 3 bundles: the core bundle, the supplemental bundle, and an authorities bundle. I understand, my lord, you'll be working from the electronic copy, and if at any stage I need to give you a cross-reference, please do let me know. There's one initial practical matter whilst dealing with housekeeping. There's no controversy about this, but we do need to raise it at the outset. You may have seen in the supplemental bundle the order of the 13th of October. It's page 45 of the supplemental bundle. And could I just ask you to turn that up? And this is the order of the 13th of October. And as you'll see, it was directed by the High Court that disclosure of written submissions to Guardian News and Media be granted on certain conditions, and it was made subject to undertakings. There's correspondence relating to the undertakings in the supplemental bundle at pages 29 to 36 for your reference. The short point is that the redacted skeletons which we've received, we, myself and Mr. Bunting and my solicitors, are subject to an undertaking, which means we can't refer to them as matters stand. And it's not in the gift of our opponents to release us from the undertakings because it was the subject of a direction. And there's no controversy. We're agreed at the bar, and we hope it can just be directed that we may refer to those documents despite the order of the 13th of October.
Right, that's all agreed, is it? Yeah, okay, thank you.
Thank you, I'm grateful. Before I start my submissions, I should like to tell you the route I propose to follow.
Well, before you do that, because it may affect the route you want to follow, can I just say 1 or 2 things, Ms. Gallagher? First, this is a public hearing, and it is being live streamed. If anything were to be said that was inappropriate, I have a button here that I can press because there's a 90-second delay on the live stream. I'm sure that won't happen, but I rely on counsel to exercise appropriate discretion. The second thing is this, that the courts looked at this case quite carefully, and we're going to have to finish the argument by noon tomorrow, come hell or high water, I'm afraid. But we think that will be more than enough time, and we think there's every chance we might finish today, but you'll have your own views about that and will have agreed. And there are 2 things that we'd like help with from counsel. The first thing is this, which is that we're slightly interested, shall we say, in how it is that you obtained permission to appeal from my lady. Not that we're questioning the decision, but what is the procedural route by which a non-party gets permission to appeal in non-contentious probate proceedings? And because we don't want to inadvertently determine a case on a procedurally inappropriate basis. I'm afraid it's a bit of a technical point, but it's one that we would like to be satisfied about. And the second thing is this, that we're particularly interested in the question of whether the press ought to have been permitted to attend the hearing on the premise, on the basis that they would not be allowed to report anything about that hearing until the publication of the judgment. And that, on one analysis, deals with the question of a private, totally private hearing, allows public scrutiny, but doesn't fall into the trap of what the President thought was was the vice in having them there. And so we want submissions about that. And also, I'm sorry, I said 2 points, but I think it's going to be 4 in the end. We also want submissions on whether the case ought to have been listed publicly so that it was known to be happening, and that may have a bearing on the route by which an appeal is made, because the press obviously wasn't able to make an application unless it knew it was happening, and therefore the question is, should it have been informed in any sense? And one way of informing the press is by listing, which is the way that's customarily done. And the fourth thing is, anyway, speaking for myself, looking at the issues, it does seem to me rather more logical to take your third issue first, the question of the locus of the Attorney General in proceedings of this kind, because that may have a bearing on your issues 1 and 2. So it's really a matter for you how you address your submissions, which is why I make these points before you start them. But I, for one, think that the position of the Attorney General is something that is a bit of a precursor to the other points. So with those introductory points, Ms. Gallagher, over to you, and apologies for the length of it.
I'm very grateful. My Lord, on a number of the points that you've made, I think it's your second and third points, they fall within our ground 2. So that's the question of whether the press ought to have been able to attend the hearing but be prevented from reporting it until publication of the judgment, and also the issue of a public listing so that the hearing was known to be happening. So that falls within our ground 2, which relates to the fact that in our submission the President fell into error in considering this as a purely binary issue between an entirely public hearing right from the outset with contemporaneous reporting, or on the other hand an entirely closed process from which even accredited journalists were excluded. So they both do fall within ground 2, and I will ensure that I address those points when I turn to ground 2. In relation to the procedural matter about the procedural route for a non-party to appeal, I will address that in the course of my submissions. I may come back to it towards the end, if that's convenient to you, simply because it may be that those who sit beside me and behind me want me to address particular matters. It isn't something I'd intended to address today, but I will. It is quite complicated, bearing in mind the fact that the 1999 White Book is essentially the governing provision, and you will have seen some of the correspondence from my solicitor in that regard. What I intend to do is address it briefly towards the end, and if it would assist, we can provide a written note on that issue today.
Well, there's a decision of the Master of the Rolls, Lord Dyson, in a case called Wimpy, I think. I can't remember the other party.
Shall I help you with the citation in case the juniors want to have a look at it? It's 2008 EWCA Civ 12. It's Lord Justice Dyson, Lord Justice Lloyd, and it's called MA Holdings, ex parte Wimpy and Tewkesbury Borough Council.
Thank you. We are familiar with that. We're very grateful. I hope the citation assists others also. Would it be convenient for me to address that briefly towards the end? It may,
yes,
in fact,
absolutely.
be...
No, I didn't want to take you out of your course, Ms. Gallagher. I just wanted you to know that it was coming. We didn't want to fire it at you in the middle of...
I'm grateful. It may assist to say, it did seem to us that we are likely to have ample time to conclude by midday tomorrow. It seems to us it's possible we conclude today, although that may be a little optimistic. We may have perhaps the reply tomorrow and potentially the tail end of submissions on behalf of the Attorney General, unless you want to hear from the Attorney General in a different order, in light of the indication that you've given.
No, I don't think that's necessary. I'd stick to the order you've agreed.
So it may be that this particular point I can address you after lunch, in fact at the very end of my submissions. It may assist. I just don't want to turn my back and be taking instructions on the issue and discussing it during my submissions. In light of what you've said, I'm just reshuffling a little the submissions that I'm going to make. So I did intend to address you on 7 areas. First, I wanted to give a brief overview of the appeal, including the nature of the challenge and what it is not. Second, some brief introductory remarks about the open justice principle, key principle at issue in this appeal. Third, and I'll take this briefly in light of the indication that my lord and my ladies are familiar with papers, wanted to briefly deal with the practice of sealing up royal wills, just a general outline and the general statutory context. Fourth, I will now deal with our ground 3 first, given the indication. 5th, I'll deal with our ground 1, 6th with our ground 2, and 7th, I'd intended to address you briefly in relation to the question of relief. You'll have seen in the skeletons that the issue of relief is not delved into by the respondents, but we thought it would be helpful just to give an indication. You'll be aware, of course, from our submissions and our application, that what we seek here is a rehearing of the matter.
Well,
with a different process.
We were wondering about that. Paragraph 4 of what you call a prayer, which we don't normally see in a notice of appeal, paragraph 4 suggests there should be a rehearing, but we don't see it in your skeleton argument.
Yes. May I address you on the relief issue towards the end?
But what's the answer? Do you really seek a rehearing?
Yes, we do.
On if any of your grounds succeed in any respect?
Yes, that's our primary position. And we're, of course, content to address you on alternatives should you need to hear from us on alternatives. But our position is that this hearing proceeded on the 28th of July last year, 2021, on the wrong basis from the outset.
Wrong procedural basis.
Wrong procedural basis from the outset, and that it should be reheard.
But you don't challenge the findings or holdings of the judge, do you?
No, but I did intend to address you on that in relation to our first ground. You'll have seen that the materials that we, on our first heading, you'll have seen from the papers that we have, my lord, that we simply don't have the substantive materials which were before the President of the Family Division when he took that substantive decision. We weren't present at the hearing on the 28th of July 2021.
So what materials don't you have? I mean, in generic terms.
Well, very briefly.
You don't have the will, but neither did he, and neither do we, for the avoidance of doubt.
Well, may I give you an indication of what we've got, which is extremely limited. And I'm glad that you have varied the direction in the order of the 13th of October. If you turn to the supplemental bundle.
Well, Ms. Gallagher, before you do that, I presume you're going to the skeleton arguments that were filed below.
Yes.
That are heavily redacted.
Yes, precisely.
And I made a direction and sent it out that we should be provided with unredacted copies. And we got back a flurry of, well, no one's going to rely on them.
We don't have them.
So
I don't understand that we saw that correspondence. What we have are simply those two redacted skeleton arguments. You'll notice at page 13 of the bundle.
I'm sorry, what correspondence didn't you have? Because the correspondence was sent out by the court.
I'll just ascertain what the position is. We haven't seen correspondence back to the court.
there have been emails from the lawyer who was dealing with the matter.
I'll take instructions on that. But certainly I have not seen correspondence.
Because when I saw those, I thought, well, those aren't much use to anyone, and so I requested our lawyer to seek unredacted copies to be sent directly to the lawyer in case there was any concern about security if it went through the normal Court of Appeal routes. And there was some correspondence in reply. I'm afraid I haven't got it in front of me, so I can't recollect whether it's from each of the parties, where we were told, well, you don't really need them because no one's going to rely on them.
So, my lady, I don't have sight of that correspondence. Just whilst I'm making my submissions, I've asked those behind me just to take a look at that to see what's happened. But as you'll know from tab 2 of the supplemental bundle, for example, we have pages upon pages that look like this. And indeed, page 13 of the bundle.
Got the benefit of the judge's judgment where
yes,
he analyses the submissions.
That's precisely it.
Which is a pure matter of law.
Yes, that's precisely it. So we have the judgment. So from the judgment we can infer certain matters. And we obviously have the paragraphs in those submissions below which address the specific issue about the two initial procedural decisions. May I just start by just indicating, I'd indicated that my first heading was that I wanted to deal with the nature of the challenge and what it is not. I've come slightly out of order in light of the question, but may I just come back to that because it does, in fact, grapple with the question my Lord has put to me about us not challenging the substantive decision at this stage. So Guardian News and Media is appealing against the order of the President of the Family Division dated 16th of September 2021, sealed on the 12th of October 2021, which appears in the core bundle at page 40. Now, at issue in this appeal is a series of decisions, two decisions in particular, made by the President a year ago on the 28th of July 2021 at the hearing of the application by the Executor that His late Royal Highness's will be sealed up, that no copy of the will be made for the record or kept on the court file, and as we can see from the judgment, that the value of the estate be excluded from the grant of probate. And as you say, my lady, we can see that from the judgment itself. It's in paragraph 1, core bundle, page 45. The decisions at issue in this appeal are two procedural decisions made at the outset of that hearing in July 2021, namely, first, to grant the application made by Mr. Crowe, Queen's Counsel for the Executor, and supported by the then Attorney General Michael Ellis, QC MP, to conduct the hearing of the substantive application in private. And second, to grant a prior preliminary application, also made by the Executor and supported by the Attorney General, to the effect that the hearing to determine whether the substantive hearing should be in private should itself be in private. And we have the summary of those submissions, page 51 of the core bundle, paragraph 30 of the judgment, and then we see in the redacted skeletons some paragraphs relating to that, including a reference to a draft order which we understand the court don't have. Now, the judgment then handed down on the 16th of September 2021 addressed both those two initial procedural decisions, which we challenge today, and the substantive issues together. And on the substantive issues, of course, the President ruled that the will be sealed up. It's understood he also granted the Executor's application to exclude the value of the estate from the grant of probate. And he also gave guidance as to the length of time for which royal wills should be sealed up, namely a 90-year period, and the likely procedural and substantive approach to any future applications to open a sealed will prior to the expiration of that 90-year period. And, my Lord, your question, it is right that the substantive decision regarding the sealing up of the will, the exclusion of the value of the estate from the grant of probate, and the process the High Court should follow in respect of unsealing royal wills are not at issue today before this court in this forum. Rather, the Guardian challenges those two initial procedural decisions taken, as we understand it, at the outset of the hearing on the 28th of July, reflected in the judgment published on 16th of September 2021, subsequently reflected in the order dated 16th of September, sealed on the 12th of October 2021. Now, the Guardian does not and cannot, at this stage, challenge the substantive decision taken at a hearing that they were not present at, based on evidence, including a witness statement filed on behalf of the Executor, and written legal submissions which they have not seen, and based on oral submissions which they did not hear. And that's why this appeal, at this stage, does not challenge, nor could it challenge in our submission, that substantive decision, or those substantive decisions reached by the President.
Well, you have the President's reasoning in full detail. And the question I would ask is, do you challenge, or I don't see how you can, having not put a notice of appeal in about it, but you know what order was made, you know that on appeal you can only challenge the order. Of course, you take into account the reasons given in the judgment for making that order. Surely you are able to note from the judgment the evidence upon which the judge relied and tell us whether you challenge what he decided, or at least say, I would challenge what he decided if I knew X, Y, and Z.
So, my Lord, our submission is this is not the forum for that. And that
Sorry,
the Guardian
it's
has,
not.
this is not the forum for that. The Guardian has taken the view entirely responsibly, I'll take you to the correspondence in a moment, that it simply doesn't know the full detail of the arguments which were advanced. It's got the benefit of a public judgment which summarises the issues, but it doesn't have the underlying evidence,
Well, then we can assume, can we, that at the moment there is no challenge to the substantive decisions.
At the moment, no.
Okay.
Not in this appeal. But that's not to say the Guardian may not wish to challenge it later if there's a process which is fair, at which it can participate, which it can see the full materials, and which it can make submissions.
Ms Gallagher, can I just ask you a question about that? Would it be your submission, and it must be, I suppose, if you're asking for a rehearing, that you would have locus at the rehearing of which you were present on whatever terms to make submissions on the substance? And if so, on what basis?
So the first issue is that we wish to have a rehearing related to the very initial decision. So the decision at the outset
I
was...
follow that, but we're not talking about that at the moment. We're talking about the substance.
So in respect of the substance, I'll have to take instructions on our position if the court does wish to hear what our position would be at that stage.
I'm not asking that question. The question is, would you have locus? Assume for the moment that you're right and that you should have been given access to the hearing on whatever terms, and terms could have been made. Is it your position that you weren't there merely to attend but had substantive interest and could make submissions on the substance?
Yes, in short.
You could.
You could. On what basis?
So we can obviously address you on this. Could you just give me a moment? I'm very conscious that isn't the scope of this appeal, but I'm quite conscious that the court wishes to have an answer to it. May I indicate that, given the public interest here, our position is very likely to be, at a rehearing, that we should be heard on the issue regarding sealing up of the will. But I will have to take instructions on it because it's simply not, that's not the appeal as formulated.
So you'd be making an application to be a party?
We're not making any such application today.
No, understood. But the route by which you say you would take a full part in the substantive hearing on a rehearing would be by being a party, would it?
I will have to take instructions. I'm afraid this is obviously not within the scope of this appeal, so we weren't intending to address you on this today. I can hear that the court wishes to have an answer. May I just have a short pause to take instructions on the issue?
Yeah, the reason...
Given that you've raised it at the outset today, and I am keen to give you a clear answer.
Of course you may. You know, we're very keen to hear the answer, but just so you know why we're interested, we're interested because the position and status the press would occupy at the substantive hearing, if you're right, is critical to the question of what relief we grant if you were right on other issues. So if it turns out that you're wrong about that, then it might be much less likely that one would order a rehearing. But if you are right that you have locus, I don't like using Latin words, you have status to attend the hearing and make submissions on the substantive issues of sealing and of the failure to annex the value of the estate and indeed the length of sealing, then that's a different question. So we do need to know what your position is.
Yes.
And as an addition to that, what documents you say you would be entitled to see for the purposes of making the submission, because we have to see where this ends, not merely where it begins.
Of course. I'm very grateful for the indication at the outset on this point. It seems to me that on the two decisions which we challenge, the first decision which we challenge is the very initial application made by the Executor, supported by the Attorney General, to the effect that the hearing to determine whether the substantive hearing should be in private should itself be in private. And that is unaffected by this issue. But the second decision, which is to grant the application made to conduct the hearing of the substantive application in private, is potentially affected by this. Now, of course, even in the event that the press is present as a non-party, but observing, it remains the case that we will be seeking a rehearing in any event.
Well,
for a range of reasons, but this is an important point.
Well, it is, isn't it? Not least because in your helpful skeleton, you give examples, including one that the Master of the Rolls outlined in his opening submissions about what might be called lesser interference in open justice.
Yes.
So, but it now seems to be that is not in fact your case, and that wouldn't have been adequate because you say you should have played a full part in the whole proceedings as either a party or an intervener with a full speaking, arguing part with access to the papers. So I'm just struggling slightly to see how that submission or that new approach, what feels new to me, fits with your submissions on ground two.
Of course, and I'm afraid we hadn't anticipated that this would be a question arising, so it's entirely my fault that I hadn't anticipated it arising.
You must have done, Miss Callahan, because you're coming here to ask us to unpick the entire hearing before the President and to send it back for a re-hearing with you there. You can't tell us you hadn't thought what part you would have to play or want to play, or that we were going to just leave it open and say to the family division, do what you like when we send it back. We've got to give direction. This is the first such case since Brown, but it's a much more central challenge than there ever was in Brown. And so obviously the Court of Appeal is going to want to say what the position is if you win your appeal.
Of course, and this of course is key to the issue of relief. I'm in your hands as to whether you wish me to take instructions immediately on this issue or whether I proceed, because it doesn't in fact appear to me to impact on the majority of my submissions, and I can return to it when we deal with relief. I think it's likely, given the timetable, that we'll reach relief immediately after lunch. So it may be convenient to do it that way rather than being disruptive.
I mean, you may find you get there more quickly because a lot of your submissions are not really disputed by anybody. I mean, nobody suggests that there is not a principle of open justice. I don't know what authorities you're thinking of taking us to, but I mean, speaking only for myself, I've given millions, not millions, but many decisions in which I extol the virtues of open justice and shun the idea that justice should be closed in every conceivable circumstance. So the principle that there should be open justice is absolutely uncontroversial. But I mean, I'm not trying to stop you making those submissions, but what we are asking you now by way of questions is very controversial and central to the nub of your appeal, because if you're wrong about it, and you actually have no status to appear and make submissions, then even if you're right, you probably only get a direction from this court that the learned judge, the President, ought perhaps to have considered a little different process.
So it's essentially the distinction between declaratory relief and a rehearing
Yes.
Being required. I'm conscious of that. Could you just give me a moment? I think it does make sense to take a moment, if we may, just to confirm the position. I have an immediate answer, but I just want to check the position with my instructing solicitors.
Right. Do you want us to rise for a couple of minutes?
Yes, please. I'd be grateful.
We will.
very reasonable. That comes out very reasonable when you said it makes it to avoid that. Not circular, the evidence is that. Jonathan Swift. That's why it's paragraph 6 of the order exists. As soon as they come back and say they've got some,
But when you just tell us street, they can squeeze, they won't. They're not bound by Yes.
I'm very grateful. I hope this may assist with the questions at the outset. So there's 3 matters I want to address you on at this stage in light of the instructions I've taken. The first concerns the correspondence that you referred to, my lady. I understand there was correspondence on the 13th of July with, I believe, a court lawyer rather than the court's clerk, with Charlotte Fraser, the solicitor, and we were not copied to that correspondence. We've ascertained there was correspondence. We hadn't seen it.
Well, I offer my unreserved apologies because I'm astonished because the lawyer is extremely effective and efficient, and I've never known that happen before. So my apologies to your team.
We're very grateful, and it seems with so many of these things, we're essentially in the Donald Rumsfeld unknown unknowns and known unknowns territory. So we simply didn't know about it. But I confirm that. I'm told the correspondence was 13th of July, and there was some earlier correspondence to which we were copied because my solicitors took responsibility for preparing the bundle, and there was some discussion about redacted and unredacted versions of the skeletons going in at that stage. This particular correspondence we weren't copied to. So I'm afraid that also means we didn't have an indication in advance that this was a matter that was troubling you, my lady. So apologies for looking...
Well, it was only troubling us to the extent that we couldn't read the document that people were putting in a bundle.
And similarly, it was a concern for us. I mean, you may have seen one of the pages is in fact upside down, but given that it's entirely blacked out,
I mean,
it makes no difference.
I think I understand that's unfortunate and everything else, but it's not really the most important thing that
No, of course.
you adjourn to ascertain.
Of course. 2 other matters. I'll deal with one brief point and then come back to the main issue, my lord, which you raised with us. So one of the questions which you raised earlier, my lord, was the issue about whether the press ought to have been able to attend the hearing as a private hearing, but for there to be a delay on reporting until the publication of the judgment. And I'll come back to this when I turn to ground 2, but in short, we agree. That is one of the less restrictive options, which was available to the court below, should have been considered. And there's many, many examples where an approach like that was adopted in a range of contexts, including in the criminal context, the Incidel case, including in family proceedings, the Poppy Worthington case. There's a wide range of cases where an approach like that has been adopted with delayed reporting. And third and key point relates to the matter, my lord, that you've raised, and I'll return to this again when I deal with relief, but I hope it's helpful to give an indication of our position at the outset. Guardian News and Media and my instructing solicitors for Guardian News and Media have attempted throughout this process to be proportionate and responsible. I hope you'll have seen that from the correspondence in the supplemental bundle. And for that reason, I make these submissions provisionally on the basis of the information known to us currently. And Guardian News and Media's position is that it would be highly unusual for them or for any other media organisations to be a party to proceedings such as these. Their normal role would be to be in a third-party intervener role or akin to a third-party intervener role. And it's anticipated that submissions they would wish to make on substantive issues would be likely to relate in particular to open justice issues relating to the substantive matters before the court, balance of the public interest, Article 10 issues, but in an intervener type role rather than a party. Now, of course, they cannot say for sure that that's a role that they would wish to take here, acting in a proportionate and reasonable way. What they would intend to do is, having seen the full material, in the event that there was a rehearing of the initial decision about the hearing taking place entirely in private with them excluded, they would then be able to observe and to see certain documents, and they would then take a view. But provisionally, their view is it's likely that they would wish to be a third-party intervener. And indeed, this also ties in with the issue we deal with in round 3 relating to the public interest and the role of the Attorney General, because we anticipate that there's also others who may have value to add for the court. For example, archivists, historians, and others who may also have submissions to make in a third-party intervener way related to both the issues concerning His late Royal Highness the Prince Phillip, the Duke of Edinburgh, but also the more general issues about the approach to be adopted to the sealing of royal wills and the process to be followed going forward. And we're conscious that, of course, there was a long history of third-party interveners without specific rules being in place in a range of other contexts before you had the Supreme Court rules and the specific rules which now apply to interventions in other contexts. And there's no specific express provision for third-party interveners under the non-contentious probate rules. But in our submission, that role is permissible within the regime, and that's a matter on which the Guardian would wish to be heard on a rehearing at the court below.
Yes, well, it would be helpful if you put that those submissions in a brief note for us as soon as you can. It would also be helpful if you were to tell us what are the documents that you need to see, bearing in mind that you have seen the full judgment of the President, in order to enable you to say precisely what role you want to play at the renewed hearing.
So in order to, taking it in stages, had we been notified of the hearing last year and the application, and had we been aware of it in advance in the way that you are ordinarily in the family division, for example, with reporting restriction orders, or in other contexts, had we received a copy of the draft order in advance and notice of the application, we could have addressed that matter immediately at that stage. And one of the unfortunate impacts of what's happened here is that we're now in the Court of Appeal dealing with these issues a year later in circumstances where we simply didn't have the materials and didn't have the notice. And although much reference is made throughout the documents to the analogy of CPR 39.2, of course doesn't apply strictly here, there was no following of the process in CPR 39.25, which would have involved the order being published. You'll have seen from the correspondence, my solicitor Jill Phillips at The Guardian had to chase to obtain a copy of the order, eventually receives it in October. In terms of materials which would be needed, may I return to that when I deal with relief at the end, but I hope it's helpful to give you an indication for now that we anticipate it would be highly unusual for the media to be a party to proceedings such as these, and far more likely would be that it would be appropriate for the Guardian and indeed potentially others to be a third-party intervener. But that's an application which we would wish to make to the court below after determination of the initial matter.
So as an intervener, what distinguishes you from other media organisations? So if you're entitled to be an intervener, presumably any media organisation or blogger can do the same.
Well, I'm not sure that necessarily follows, because of course it would be open to any blogger or media organisation or individual accredited journalist who's not associated with a media organisation to make an application. But there would be a fact-sensitive decision as to whether or not that would be permitted. I'm conscious of other cases in which certain media organisations and certain journalists have been granted permission and others haven't. The reason I'm not jumping the gun and dealing with that issue now is because that would be very much coloured by what that initial preliminary decision is. Because, of course, if the initial preliminary decision were to be that, in fact, this hearing should proceed in public, the approach might be rather different to if the initial decision were taken that it should proceed in private with delayed reporting and with only limited press attendance, for example. And that's why I'm dealing with it because of the question that I'm asked in a high-level way at this stage, indicating what we think our likely role would be. But I don't understand the court to be asking us to essentially make that application now, which we don't think would be appropriate.
Ms. Gallagher, am I right in thinking, therefore, that the end result that you're seeking is not simply to be present as the media is normally present in open hearings, in other words, to see and observe, but to play a role beyond that?
Potentially.
Potentially.
So on the first part, there's two parts of the hearing. At the very first part, relating to the question of whether or not the hearing considering the application for the hearing, substantive hearing, continue in private. That application, the press should be notified, should be entitled to participate by making submissions. So our position on that is clear, as I hope you've seen.
That's
But on
ground one.
Precisely. On the second issue, relating to the follow-on hearing, if the follow-on hearing were then to proceed in private or in some form of process which is not entirely public, whether that is a process akin to that used in some family division hearings, or whether it's something akin to the approach adopted in the Instell hearing, at a minimum, Guardian News and Media should be entitled to be present and to observe. We anticipate it is likely that we would wish to go further, and we would wish to make submissions in a third-party intervener role, addressing open justice, Article 10, balance of the public interest. And we also anticipate it's likely that there may be others who would wish to play a similar role. Some may be content with observing only, some may wish to also make submissions. Now, it doesn't necessarily follow that to make submissions on those points, the Guardian, or indeed anyone else in a third-party intervener role, would need to see all documents. As happens in other proceedings, they may need to see only certain documents which enable them to address those issues. And the court has a wide range of mechanisms open to it to enable that material to be provided in a way which protects any countervailing interests. And that goes to the question, my lord, that you asked at the outset about whether the press ought to have been able to attend the hearing with delayed reporting until the publication of the judgment. And it goes to our ground two, in which we set out a range of less restrictive alternatives, which would have enabled, at a minimum, observation and a level of open justice, even if it's not a fully public hearing. May I return to that issue in more detail when I turn to relief at the end of my submissions? I should also indicate we of course have in mind that there's a range of other public interest points on the substantive issues which Guardian News and Media would be likely to wish to make at a rehearing, which we haven't advanced in our skeleton because our skeleton is focused upon what we say is the flawed approach to those two preliminary decisions. This is an appeal about whether, first, the private hearing about the private hearing was lawful, and secondly, an appeal about whether the private hearing proceeding as a private hearing was lawful. And that's why we haven't addressed those substantive issues, and why we seek to raise those issues at a rehearing before the court below. Now, turning back to my submissions, I had intended to then, just finishing our first heading, just in outlining our position. Now, the President came to his decision as set out in the judgment dated 16th of September and the order dated 16th of September and subsequently sealed on the 12th of October, following that private hearing from which we and all other members of the press and public were excluded. It was an entirely closed hearing, without access by accredited journalists or any other form of external scrutiny. And as you'll have seen, our position is that an entirely private hearing such as this is the most serious interference with open justice. And I say at the outset, and I'll return to this in more detail later, that our position is that this is an exceptional step and that it does require exceptional justification. And I'll turn to the fact that the Attorney General takes issue with that test of exceptionality a little later, and when I come in particular to ground two. In this case, the President decided to take such an exceptional step without even inviting or permitting members of the media to make submissions about whether such a procedure was fair or justified, and without considering alternative courses such as, for example, undertakings, as we have been subject to in preparing this appeal. And in addition, at that hearing a year ago on the 28th of July, we now know that the President also considered and decided generalised questions unrelated to this particular will itself in respect of the time limit to be applied before the unsealing of royal wills, the process to be followed in the event of any applications to unseal prior to the expiry of that period, and the process to then be applied for unsealing wills upon the expiry of that period. And as you'll have seen from our skeleton, from our grounds, our submission is that the President's conclusion was unlawful on 3 grounds. First, fairness, ground 1. And our submission is that the President erred in law in denying the media an opportunity to make submissions on that very first issue of whether the hearing of the application to seal up the will should proceed in private and with all press representatives excluded. Second, our ground 2 is that in any event the decision was disproportionate and unjustified, and the decision to hear the application to seal up the will in private with total exclusion of any external scrutiny was disproportionate and unjustified. And that goes to the issue about less restrictive means, including the alternatives, my Lord, that you indicated at the outset of this hearing in your questions. And then our third ground is the role of the second respondent, the Attorney General, and our submission, in short, on ground 3, is that the President erred in law in directing himself that only the second respondent, the Attorney General, could speak as a matter of law as to the public interest on both the initial procedural question, on the issue of media attendance at the hearing, and also on the substantive issues arising in the appeal concerning both the Executor's application to seal up the will, the associated applications, and the more general issues concerning the approach to adopt to the sealing and unsealing of royal wills in future. And that is inherently linked to the submissions that I've just made, linked to the question, my Lord, that you put to us regarding the potential role of third-party interveners, such as Guardian News and Media, such as other media organisations, or indeed historians, archivists, and others who have particular expertise in those issues. Now, the process from Guardian News and Media's perspective was they knew nothing about this on the 28th of July last year. They had no sight of any draft order in advance, despite they and other accredited media organisations routinely receiving, solely for legal reasons and not for publication, reporting restriction orders in the draft reporting restriction orders in the most sensitive of cases in the family division on a regular basis. They had no idea the hearing was taking place, and the first they knew of it was when the judgment was published on the 16th of September. I'll give you the page reference, but don't ask you to turn it up. In the supplemental bundle, you'll then see correspondence from Jill Phillips on behalf of The Guardian on the 21st of September 2021. Starts at page 19 of the supplemental bundle. And where she indicates paragraph 2, my Lord, I'm conscious of the question you asked about the particular role of The Guardian. She indicates at paragraph 2 of that letter The Guardian's long-standing interest in reporting issues relating to the royal family responsibly and fairly, and in working towards greater transparency in this regard. And by way of example, she indicates that a journalist at The Guardian was the litigant in the Evans case, the Prince Charles letters case. And she also indicates in the letter The Guardian's long history of engagement in issues concerning transparency and open justice. And indeed, you'll see that from the authorities bundle, where Guardian News and Media is quite often the organisation raising the issue. So she sets out in that letter the fact that The Guardian's concerned at the procedure adopted in the case from what they can see in the judgment of the 16th of September, and requests certain documents so that she can understand the process that was then followed. You'll see there's then chasing correspondence, 27th of September, 5th October, 11th of October in the supplemental bundle. And then ultimately on the 12th of October, an order is received, dated 16th of September and sealed 12th of October. And then there's following correspondence related to the undertaking issue that we addressed at the outset. And that correspondence also deals with the knotty and not straightforward issue of the fact that the civil procedure rules are not the procedural rules applying to this appeal, but rather the non-contentious probate rules 1987, with Rule 3 applying the rules of the Supreme Court as they were in force on 25th of April 1999, and hence we brought rather old white books. We've had to delve into those, and you'll have seen in the correspondence that my solicitors made clear in the application the unusual position that we were in. And indeed, I could see the Court of Appeal lawyers had some difficulty grappling with it also, because of course it wasn't received in the ordinary format, because we were following the 1999 provisions in line with the rules of the Supreme Court as they stood at that time. And I'll return to that question about a non-party and permission to appeal at the very end. I'm conscious of the question you asked in respect to that too. And I also were content to provide the note to give more detail on our position in relation to the third-party intervener issue, given the complexity of this point about the rules of the Supreme Court as in force on 25th of April 1999, and the fact that I anticipate you will not readily have available the respective white book with those provisions. We're content to also reduce that to writing so that you have it in more detail. And we'll do that. I can address you on it briefly after lunch, but we'll give you more detail in writing. Of course, we then received permission to appeal by my lady, Lady Justice King, on the 19th of January. That's in the core bundle at page 65. And we're mindful that in granting permission to appeal on all three grounds, and my lady, you indicated that there was a real prospect of the applicant succeeding on the first ground, and that the second and third grounds flowed from that. In respect of our second heading, I wanted to address just briefly, and I'm conscious you're aware of the case law and you've had an opportunity to review the authorities before you. We did want to briefly address some key principles in respect of the importance of open justice. And my lord, I'm conscious that you indicated at the outset this is a matter extremely familiar to the court. And I'll take this quickly. May I give you some cross-references as I go? And this is before I come to the substantive submissions. So first, in the authorities bundle, the Kane-Toddler case, which is tab 12 of the authorities bundle, page 254 E to G in the electronic bundle. Addresses the issue of the purpose of open justice.
So which page was it?
Page 254. And you'll see there's reference at the outset to Scott and Scott, that the limits to exceptions to the general principle that proceedings should be conducted in public could not depend on the individual discretion of the judge. And there's, in that passage, an outline of the vital importance of the principle of open justice. And you'll see paragraph 5, further down the page, that any interference with the public nature of court proceedings is to be avoided unless justice requires it, and reference is made to some specific circumstances where Parliament has indeed recognised situations in which interference is necessary, which do not apply here. And maybe draw to your particular attention at the comment, it's at D on the page, where the court draws attention to a comment in the judgment of Sir Christopher Stoughton in Ex Parte P, 1998 case in Court of Appeal, and where he stated when both sides agreed that information should be kept from the public, that was when the court had to be most vigilant.
So where are you reading?
So that's on page 254, and it starts at D. Do you have that, my lord?
Yep.
He said the need to be vigilant arises from the natural tendency for the general principle, the open justice principle, to be eroded and for exceptions to grow by accretion, as the exceptions are applied by analogy to existing cases. This is the reason that it is so important not to forget why proceedings are required to be subjected to the full glare of a public hearing. It's necessary because the public nature of proceedings deters inappropriate behaviour on the part of the court. It also maintains the public's confidence in the administration of justice. It enables the public to know that justice is being administered impartially, and it can result in evidence becoming available which would not become available if the proceedings were conducted behind closed doors or with one or more of the parties or witnesses' identity concealed. Makes uninformed and inaccurate comment about the proceedings less likely. If secrecy is restricted to those situations where justice would be frustrated if the cloak of anonymity is not provided, this reduces the risk of the sanction of contempt having to be invoked, with the expense and the interference with the administration of justice which this can involve. Of course, the description given there of the importance of open justice is echoed in a series of other cases, and we've summarised in our skeleton and in the documents before you some of those key authorities. May I just give you some additional references from the bundle that we wish to draw to your attention. That part of the Kane-Todner judgment is approved in Ray S. The reference is tab 15, page 299 of the authorities bundle, paragraph 29. And also in the Ray case, tab 24, page 530 of the authorities bundle. Now in Ray S, which begins at page 285 of the authorities bundle, we draw to your particular attention page 295, paragraph 18, and page 298, paragraph 28, and paragraphs 30 and 32 to 35. Just taking those in order. At page 295, paragraph 18, under the heading the general rule, it's at the bottom of the page. Do you have that, Lord and my ladies? That refers to the specific role of the press as the watchdog of the public. The ordinary rule is that the press, as the watchdog of the public, may report everything that takes place in a criminal court. And then reference is made to that being a strong rule in the European jurisprudence that can only be displaced by unusual or exceptional circumstances. And then the importance of a fact-sensitive review by the court when there's a request for a departure from it. Paragraph 28, which starts at page 298, deals with Article 10. And again refers to the vital role in a democratic society played by the media.
Do you say those principles, which are well known and set out there in the context of what happened in a criminal case, apply without moderation to the factual context we're considering here?
Yes, so we say those principles do carry over to this context.
Without any moderation at all?
Well, those particular principles do apply, we say, without moderation. I mean, plainly the context is different. So in terms of a decision which may be made about the relative weight to be given to competing interests, it may differ depending on context. And Ray S is in a criminal context. So, of course, the context ultimately may mean that different weight is given to different factors. But those principles, the principle at paragraph 18 about the press as a watchdog of the public, the principle at paragraph 28 about the central importance of the media to a democratic society are not criminal context specific. Indeed, the quote of paragraph 28 is from the Reynolds case, which is not a criminal case.
But it's all very well as a principle, but it does rather ignore part 39.2, which are the rules that apply to civil proceedings, which make specific provision for the circumstances in which cases can be heard in private.
Well, first of all, CPO 39.2 doesn't apply directly here.
We know that.
Secondly, of course, by analogy, it was used as a helpful mechanism.
Well,
but ultimately,
you don't say it shouldn't be looked at by analogy, do you? You don't,
No, we
there's
don't-
no
we don't say
ground of
that.
appeal about that.
But in applying it, the underpinning principles are those set out in the case law, and the case law domestically and the case law in Strasbourg. And when deciding whether or not there should be an exception in a particular case to the open justice principle, and then when deciding the extent of the exception to the open justice principle, so just how limited open justice should be, these principles are key. And they're not criminal specific only, in answer to the question from my lady, as is clear from the authorities that we put.
Yeah, but the problem is that non-contentious probate is not litigation. It's not criminal litigation. It's not anything like the type of litigation for which the press acts as a watchdog to ensure that the courts are behaving properly, honestly, and are scrutinised. It's a completely different animal. And 39.2 actually refers to it.
So, my lord, I would submit that, of course, it's a different animal to some of these particular cases and the particular context. So, in respect of criminal case or an inquest, for example, some of the cases relate to family proceedings. So, of course, it's context specific. But the context here, which I was going to come to in a moment in relation to our grounds, is that the statute has a presumption of openness. That's a key piece of the statutory context. And whilst the submissions that are made against us by the respondents refer to this being inherently private, Parliament, in the primary statute, has a presumption of openness in respect of the sealing of wills. And there are also a series of important aspects of the public interest, even on this issue. Now, I would indicate that I would suggest that there are three core public interests at issue in this context, non-contentious probate rules, in this appeal, on the procedural issues. And there's a wider range of other public interest matters which would arise at a later stage if there were to be a rehearing and if the Guardian were to be making submissions at a later stage about the substantive issues. But at this stage, the first is, in our submission, public interest in open justice in all court contexts, including this context, ensuring that there are only derogations from open justice where strictly necessary. And that's not specific to criminal proceedings, and it applies equally in the context of the non-contentious probate rules.
And that's spelled out, actually, in terms in 39.2.
Yes.
So you know, that's not just recognised through judgments and authority, it's within the rules.
Yes. Thank you. The second, in this particular context, my lord, given your question, relates to the public interest in the role of the monarchy and the question of equality before the law, and whether the ordinary law, including the ordinary presumption of openness and access to a will, should apply to the royal family, or whether there's to be a specific carve-out for the royal family, not reflected in statute.
Well, it is reflected in statute as far as the monarch is concerned.
The monarch is I'm referring to the royal family other than the monarch. The monarch's position specifically is different.
But again, going back to 39.2, which of course I completely accept doesn't strictly apply, that's giving a potential carve-out for anyone.
Well, it's a factor to consider, isn't it, in 39.2? Because if it's necessary and it falls...
No, all I'm saying is that in your number 2 is you're saying, you know, so it's special for the monarchy, and all I'm saying is we just need to bear in mind that 39.2 specifically anticipates that this could apply not just to the royal family or the monarchy, but any person.
Yes, although in 39.2, it's obviously phrased in such a way, my lady, so that those factors which are dealt with under 39.2.3, including uncontentious matters arising in the administration of trusts or in the administration of a deceased estate at point F, and the others, including, for example, national security, personal financial matters, and so on, they're not enough. It's got to be necessary to sit in private to secure the administration of justice, with the court being satisfied that one or more of those factors apply. Of course.
I accept that completely. I was simply highlighting that if you were suggesting that this was only to apply to royal personages, that's not my reading of 39.
No, but the point I was making on this point, and my apologies that it wasn't clear, is that there is a public interest in the particular issue in this, with the substantive issue which arose in this case, which is not the subject of this appeal, because this appeal relates to the earlier preliminary procedural questions. There is a question, which is a public interest matter, about the role of the monarchy and whether royal wills, with the exception of the monarch who is different, should be treated differently. So there's an equality before the law aspect to this, and 39.23F doesn't go to that particular issue. And the extent to which the ordinary law of the land should apply to the royal family is, in our submission, a matter of constitutional importance and debate. There have been a number of recent concerns about, by way of example, exceptions to equality and freedom of information legislation, scrutiny of royal estates by the police and the criminal justice system, and other statutory requirements that have caused public concern. And any perception that the royal family may be above the law raises public interest issues in itself. It's a matter of concern in a democracy, particularly where the sovereign is required to give her consent to new legislation through the Queen's consent process. But the third aspect of the public interest that I just want to indicate at this stage is the public interest in the way in which the assets of the royal family are distributed. The royal family enjoys the financial support of the public purse by means of the sovereign grant. The royal family also has its own...
The public interest in the way in which the assets of the royal family are distributed, did you say?
Yes. And the royal family, of course, has its own financial interest through the Crown estate and its own assets. But any lack of transparency or perceived lack of transparency of royal finances and the ongoing necessity of the sovereign grant in a democratic society are issues of legitimate public debate. So there is a public interest issue related to an understanding about how much money the royal family has and how it chooses to divest of its resources through wills. That is, in itself, a matter of public importance. So, of course, it's a very different context to some of the contexts in the cases before you. But any suggestion that that somehow weakens the public interest in this context is not something with which we would agree. May I give you some other references, just more generally, on importance of open justice in the limited authorities we've given?
Have you got any authority on your second and third public interests that are core, you say?
No. One of the difficulties, of course, here, as you'll have seen, is that although for a century there's been a routine practice of these hearings being conducted in private and wills being sealed up, as the President indicates in his judgment below, there's no known record of any judgment or statement of reasons. So, although there's a long-standing practice, we're in a vacuum as to the reasoning because it simply isn't set out, and he records that in the judgment at paragraph 4. So I'm making those submissions to you as a matter of principle because we're essentially treading new ground here.
I mean, I understand that you're seeking to tread new ground, and that's never a reason for not listening carefully to the arguments. But I'm just slightly concerned that you express a general public interest in the law applying equally to the royal family, they're not being above the law in any respect, the public interest in the way the assets of the royal family are distributed. And one might have thought that in other contexts those might have been alluded to. And we do see, I mean, I know this is not particularly relevant, but we're judges and we're not blind to what your client published this week in its newspaper. And obviously one of the things that your client is particularly interested in is indeed the money, because that's what the focus of the 2 articles published this week is about this case. So if there were authority on this question of public interest in knowing about the finances of the royal family, that would be of great help, wouldn't it? But there isn't, you say. I mean, I can see why there might not be, but Just asking.
Yes, we take the point, and you're quite right. But we, of course, also see why there may not be. It's an unusual position to be in, to have this long-established practice, which has occurred entirely behind closed doors, with the reasoning also being behind closed doors.
Yes, it is not as if the royal family has never been involved in litigation before.
No.
There's been a fair bit even in recent years.
Similarly, there's no authority against us on it, my lord. It simply is, we're in new territory, and they're first principle submissions in relation to the public interest. And there are 3 points that we would make about the particular public interest in this context. But
I mean,
may I also...
you haven't mentioned or said a word about the judge's reasoning on this aspect, which was really founded on the dignity of the sovereign and the sovereign's family.
And I am going to come to that. I'm going to come to that when I turn to the specific grounds. We also have particular concerns, which I'll come to, about the reasoning of the court below, referring to a prurient press having purely commercial interests and so on.
Leave the prurient press, if I can say the word properly, aside. But there were two substantive reasons the judge founded upon. One was the dignity of the sovereign, and at a very sad and stressful time for the sovereign and her family. And the other was the privacy of the sovereign in relation to personal matters that were not and would not for any other person be in the public gaze. It's one thing to say that this is just an ordinary will of an ordinary person, but everybody knows that the interest in wills, I mean, I'm old enough to remember when in the newspaper they used to publish wills, and they used to say John Smith left £1,224,164.32. I haven't seen that for years.
It still occurred in the Telegraph and the Times until relatively recently.
That's it. Okay. Well, I've obviously not drawn my attention to it. But the point I'm making is that is of only passing interest to the world, whereas we have to be alive to the reality, which is that figure in relation to this will and other members of the royal family would be very much more than just passing interest. And as we see from the articles in The Guardian this week, it would be precisely what you apparently want to know.
Yes, I am going to come to those points. And in short, because you've asked me now, those points about the dignity of the sovereign and privacy simply do not tackle our ground one. And they do not tackle our ground two, because of course, even in the event that the court considered necessary to have particular protection in respect to dignity of the sovereign at a particular time, given that the hearing was in July and the death had occurred only in April, there were other options, such as delayed reporting, for example, as you indicate, as per the question you asked me at the outset with your 4 points.
I mean, this is why I've been asking for focus in your submissions, Ms. Gallagher, because it is one thing to focus your submissions on saying we should have been allowed to come along, not to report initially, but then to report the argument on legal questions once the judgment was revealed. It's quite another thing to say what you're actually saying, which is that you should have been allowed to be an intervening party to make submissions on the substantive issues before the court, and the hearing should have been entirely in public. And if that, and I now know that is your submission, but it's of such a different order to the first submission, the one I put to you in opening this morning, that to found them on the same ubiquitous principle of open justice in the same breath, at least for me, I find difficult to understand. I think it's very much one thing to say the judge went a little bit too far and he should have allowed the press in to scrutinise a otherwise private process, provided they kept to reporting later questions of law. It's quite another thing to say you have a right, because of these three public interests in treating the royal family like everybody else, and the public interest in the way the assets are distributed, to know everything, have it all in public, to make submissions. And the logical conclusion of what you're saying is you should be permitted to see the will, isn't it, in order to make those submissions. and even this court hasn't seen the will, I say again, nor did the President.
This is why we were anxious not to jump the gun on the question you asked us earlier, because the first question is a limited one, which is about the initial decision to hold the hearing about whether or not this should be private in private. And in our submission, the Guardian has a very strong argument for saying that that approach was procedurally flawed. The Guardian then wishes to take part in that once a decision is taken on whether or not the hearing should proceed entirely in private, as it did already, which we say is flawed, whether it should proceed entirely in public or something in between. That's the point at which the Guardian and others could consider whether or not they should be entitled to make submissions as a third-party intervener. That's why I was careful in what I said earlier, that our presumption at this stage is that the Guardian would wish to play that role. I believe it's a decision that they would carefully take at a later stage. It doesn't actually go to that first issue in this appeal before us.
I mean, by disposition, I'm incredibly hostile to arguments that say this will open the floodgates. But I think in this particular case, the way you're putting your argument is actually suggesting that the floodgates should be opened because you want now to attend as an intervener, but of course, without telling us what precisely the documents are you wish to see, what the submissions are you would be likely to make, or indeed challenging the substantive decision the judge made on the evidence, which was that the will in this case should be sealed. Now, that therefore does give you, unfortunately, the burden of explaining why it doesn't open the floodgates and mean that even the chink of your ground two is problematic.
So, my Lord, if I may, it's very difficult in circumstances where we were not present at the hearing, we haven't seen the documents, we didn't hear the submissions. It's extremely difficult to see how we can be...
That's the bit I don't get, Miss Gallagher. You've made that submission about 4 times. You know precisely what the judge founded upon because he gave a 100-and-something paragraph judgment. And, you know, judges see a lot of things. I used to be a judge in the business and property courts. I used to have cases with hundreds and thousands of files. But the only thing that was of any interest to anybody was the reasons that judges in that court gave in their judgment. Why is it different here?
So, my Lord, I'm conscious I've come out of order.
Well, I promise. I promise to shut up. I've been
No.
interventions.
It's important that we understand the concern of the court. So, in relation to the floodgates issue, may I address that when I turn to the grounds? I wanted to finish with giving you some key points underpinning in relation to open justice before I turn to the grounds. Okay. And I did also want to give you some references to the background history. If I do that, I'm then, rather than proceeding in the order I'd intended to, I'm mindful of your request that I start by dealing with the Attorney General's role. It does mean I'm not then going to get to ground 1 and 2 until after I've dealt with that, my Lord.
The Attorney General is important, isn't it?
Yes.
Because the Attorney General was actually joined for the specific reason of the court being informed as to the public interest. I mean, we can't get away from that.
No, but may I then, my Lord, turn to your query about the floodgates issue, which is not a concern which we share, when I turn to grounds 1 and 2.
Yes.
So in respect of open justice and the general principles, there are some more indications I need to give you. I'm not yet making the submissions under the grounds, but I need to give you some more references. To my lady's question about the criminal context being very different, may I refer you, my lady, in particular to Sunday Times, tab 29, page 633, paragraph 50b, which refers to the general principles about the role of the press, and Article 10, not in a particular criminal context.
My question was whether you say general principles apply without moderation in this context. That was the question I asked, and your answer was they do.
Yes, my answer is...
I'm fully aware of the
course.
cases.
My lady, yes, that is our position,
yes.
that those general principles apply. But on the phrase without moderation, I did indicate that it's context specific, and of course we can see that the approach which may be considered appropriate when you weigh competing factors in a criminal context could be different to that in an inquest context, could be different to that in care proceedings, could be different to that in non-contentious probate. It's also fact sensitive in terms of the nature of the individual in question. And one of the issues here, turning back to those public interest points that I made about the royal family and the particular interest in transparency in respect of royal family finances, it does mean that the royal family may be in a different position to others who are public figures, such as celebrities, for example, who have no such process as this, but who may similarly have issues about privacy and press.
That's the irony, Ms. Gallagher. The celebrities have exactly the same available process. It may not be a custom of 100 years that their wills are sealed, but they could apply.
Yes, they could. And other individuals could too. But the public interest in particular here relates to there being a general rule, as set out in statute, a general presumption of openness, and a practice here, which means there is in practice a carve-out for members of the royal family, with the monarch being different.
What I have a slight problem with is that your assumption that wills are open for very well established good reasons. You'll remember one of the questions in Brown that this court asked and never got answered. Why are they open?
Yes, and there is in the court below some consideration of that issue, because of course there isn't.
I know, but you're assuming that it's a given that wills must be open, including the amount of them, in the public interest. But there is a slight tension, at very least, with 39.2 and the exclusions in 39.2 that may apply for financial interests and for non-contentious probate. So there is the clue is in the name, non-contentious.
Yes, you do have, this is a matter of primary legislation. It's obviously primary legislation dating back some years, and the original rationale, as was complained of in Brown and in the court below, is not necessarily clear. I'm conscious that in the court below, in the redacted skeletons, we can see some arguments which were advanced as potential rationales by the executor, for example, which are then dispatched with by the executor as not applying in this particular context. But it is also a provision which has remained in place and has been considered more recently. For example, there wasn't the proposal to specifically deal with the royal family in a particular rule was, of course, not proceeded with at an earlier stage. But we understand the concern. And as with so much in this case, you're essentially treading new ground, because this hasn't been the subject of reasoned decisions before by this court or by the High Court, which we can see, because although there's a long-standing practice, we don't have publication of reasons.
Do we know whether any other person, apart from a member of the royal family, has ever applied? I mean, the executor of any other person has ever applied to seal their will?
We can certainly take. We understand, yes, but I can give you. There is a reference in Brown to there being an increasing practice of it.
Right.
And it's certainly, my lord, if you're interested in more information on that, we can obtain it for you.
Well,
we don't
one of my
have
favourite books, which is Tristan and Coote's probate practice, which you may think slightly eccentric in itself, Miss Gallagher, but I couldn't find anything about it in there. Maybe I didn't look hard enough.
there's the reference in Brown to there being no statistical material available,
Right.
Despite requests being made, because that's another frustration, again, that you simply don't have that information available to you because it doesn't appear to be gathered. And there is, in fact, that reference to the absence of statistical information is in the article that's referred to in the judgment below, but which you don't have in the authorities bundle. And if you needed that to be made available to you, we can provide it
Very helpful.
electronically. We do have, I think, hard copies, but we certainly can provide it electronically as well over the lunch break and give you the cross-reference to the absence of statistical information that it refers to. On the open justice issue more generally, before I turn to the grounds, without turning them up, may I just give you a number of other references for your note. So the practice direction at tab 19, page 399 of the authorities bundle, Paragraphs 9 to 13 deal with the fact that derogations should only be where exceptional, strictly necessary, and there's no general exception to open justice where privacy and confidentiality is an issue, and applications will only be heard in private if and to the extent that the court is satisfied that by nothing short of the exclusion of the public can justice be done, and exclusions must be no more than the minimum strictly necessary. Those passages were approved in various claimants, which is tab 26.
What does that practice direction apply to? It applies
So
to
sorry, I just couldn't hear.
interim. What does the practice direction apply to?
Interim non-disclosure orders.
Interim non-disclosure.
It starts at page 398 of the electronic bundle.
Right. And is this an interim non-disclosure order covered by the practice direction?
No, it's not.
No.
And we've provided it so that you can see in a range of other contexts the approach that's taken, which we hope is helpful in the absence of there being clear guidance on this particular issue. And those passages were approved in various claimants. I don't ask you to turn it up, but it's tab 26, page 570, paragraph 34. We also rely on Lord Justice Toulson's words in Guardian News and Media, the buttered parsnips paragraphs, which is page 428, or tab 20, paragraphs 1 to 3. And then the Ray case, which is at tab 24, commences at page 519, deals with the general underpinning principles on the importance of open justice and the underpinning principles at paragraph 37 onwards, starting at page 529. And that section, paragraph 37 onwards, draws together the strands from many of the other cases and just summarises the key principles and includes extract from the decision of the Lord Chief Justice in the In Re BBC case. And those principles as set out there do apply without moderation in this context, although of course the context is critical to what may be considered proportionate and appropriate. Now, in respect of the history of the practice of sealing up royal wills, mindful that you're aware of the papers and across the detail, I'll just give you some cross-references and not turn up any pages, and then I'll immediately move on to the grounds. The history of the practice of sealing up royal wills is set out by the President in his judgment, and as he indicates at paragraph 4, page 45 of the core bundle, the sealing up of royal wills over the past century has always been determined at private hearings, was invariably granted, and there's no known record of any judgment or statement of reasons. As you indicated, my lord, the position for the sovereign is different, but for other members of the royal family, the ordinary probate rules apply.
Do we have
See
the
paragraph
legislation about the sovereign? What is it?
Yes, that's not in fact in the bundle, but we can provide it electronically if helpful, if you wish to have it.
Yes, please.
Paragraph 10 of the judgment does deal with this. My lord, it's page 46 of the core bundle. It gives the cross-reference to those two cases from 1822 and 1862, my lord. And that's the principle that the sovereign's will doesn't need to be proved by grant of probate. and that dates from that case of 1822 in goods of His late Majesty King George III deceased. But other than the sovereign, the ordinary rules of probate apply. As we understand it, the first member of the royal family whose will was sealed was Prince Francis of Teck. See paragraph 13 of the judgment. And we note that some of those protected are not royal at all. See, for example, Leopold de Rothschild. That's in the annex, tab 32, page 664, paragraph 4. If we may put it this way, many of the other names which appear in the annex could fairly be said to be obscure members of the royal family.
Up on the former name you mentioned, I saw somewhere in the papers, you have to remind me where it was, that there was some suggestion his name may have been included by mistake.
Yes, that's right. There is a reference to that. But when you look at the full list, and I'll get the reference for you, my lady. I don't immediately have that.
I can't remember where I read that. I didn't see it somewhere. But in the judgment.
I think the issue is it wasn't under this procedure. It's a historical document, and it wasn't under this specific procedure. Could you just give me a moment? It said that it's rightly done under this procedure, but he's not a member of the royal family. But it's correct that it was done under this procedure.
Where did I receive this in the papers?
Yes, I'll find the cross-reference. I'm conscious of it, I just can't put my finger on the precise page now, but I will get it for you. But many of the other names, my lady, on that annex could be fairly be said to be obscure members of the royal family. You'll have seen the list, and that emphasises in our submission the point made by the President that it's not always been clear what the definition of a member of the royal family is. You see that at paragraph 15 of the judgment, core bundle page 47. And as we understand it, that point appears to have been the subject of confidential note, which we have not seen and we anticipate the court has not seen. You see that from core bundle page 49, paragraph 23. So there's only one previous reported judgment on this issue, the Brown case, which we have at tab 16. And again, I won't ask you to turn it up, just give you the cross references. And that makes clear that there's been a long history of sealing up royal wills. See page 315, paragraph 47. And it refers, at paragraph 28, to a highly confidential process being set up around the time of the death of Princess Margaret in February 2002 to protect the privacy of the sovereign. So that's page 312, paragraph 28. And the Brown case summarises the way in which the statutory provisions work. Wills are under the control of the High Court, which can rule that it would be undesirable or otherwise inappropriate for a will to be open to inspection, reflecting section 124 of the Senior Courts Act, which you have at tab 2 of the authority bundle, and rule 58 of the non-contentious probate rules, which you have at tab 3. And of course, in the Brown case, the former president had sealed up the will of Princess Margaret, and a man claiming to be her illegitimate son sought to go behind that order. And Lord Phillips, the Chief Justice, was concerned that the process under which the former president made the orders was not transparent, nor the criteria applied by the former president plain. We see that at paragraph 37, page 313. And at page 315, paragraph 38.
38.
Yes, page 315, paragraph 38. The court held that there was no proper analogy to the Gurrier case, as there's nothing on the face of section 124 to suggest that the court may only exercise its powers under it on an application by the Attorney General. It may be relied on by any person. And turning back to the issue of statistics, it's paragraph 41, while we're on this page. that refers to, let me just make sure that's the correct reference, page 314. It's on this page where reference is made to the wider number of applications, an increasing number of applications to seal up wills. Yes, you see that in paragraph 41, just conscious of the question you asked earlier. This question's of practical importance as we were told that there's an increasing number of applications for wills to be sealed, both Articles 8 and 10, and maybe engaged. So that's that reference. I couldn't put my finger on it
But
earlier.
is there a
when you asked me.
reported case about the sealing of a non-royal will?
We're not aware of one, no. So, my Lord, against that backdrop, I'll turn to the grounds in the order that you indicated would be most helpful. So I'll start with ground 3, the role of the second respondent, the Attorney General. And in summary, our submission on this ground is that the President erred in law in directing himself that only the Attorney General could speak as a matter of law as to the public interest on both the initial procedural question on the issue of media attendance at the hearing and the substantive issues arising in the appeal concerning the Executor's application to seal up the will and the associated applications. And in the judgment, given the challenge that we make and the scope of this appeal, the key paragraphs are very short. It's at page 59 of the bundle.
What's the paragraph in the judgment?
Paragraph 63 and 64. And at the final sentence of paragraph 64, you see the reasoning in relation to the role of the Attorney General. Do you have that, my lord and my ladies?
Yes.
So it says, I also accepted the argument that only the Attorney General can speak as a matter of public law to the public interest, and that there was legally, therefore, no role for those who might represent the media at a hearing, public or private, in putting forward any contrary view of the public interest. Now, this reasoning is presented a little differently in the skeletons before you, but in our submission, that sentence at the end of paragraph 64 is plain. The reasoning of the court was that legally, Guardian News and Media, and indeed anyone else, as a matter of law, could have no role in putting forward any contrary view of the public interest to that advanced by the Attorney General. And in our submission, that in paragraph 64 is an error of law. Now the other paragraphs...
But he didn't say that the Guardian News and Media could not put a different view about the need for an open hearing.
No, and again, we're back to Donald Rumsfeld. This was 28th of July last year. We weren't present. There was no participation by Guardian News and Media or anyone else. But the key paragraphs in terms of his reasoning on the private hearing, both the private hearing of the substantive application itself and the private hearing as to whether or not there should be a private hearing, is contained in paragraphs 63 to 64. And the other paragraphs of relevance to this, of particular relevance to this, are paragraphs 30 to 38, where he summarises the submissions that were made to him.
Which he accepted.
Yes. But the entirety of the reasoning is encapsulated in those paragraphs. Now, of course, there's other parts of the judgment which cross-refer and relate to these matters, but they're the key paragraphs. And that final sentence of 64 contains his reasoning in relation to the role of the second respondent. And we make 4 core submissions as to why this was wrong.
I mean, he accepted the submission on 39-2.
Yes, just my lord, on this point about the Attorney General. Bearing in mind that you indicated you'd be assisted by dealing with this first. There's 4 key points.
4 key points.
And this cross-references to paragraph 33 of our skeleton for your note. First, it's well established at common law and pursuant to Article 10, that's why I gave you the references to the cases that I did, that the media serve as a watchdog in court proceedings, whatever those court proceedings may be, and they serve as both the eyes and ears of the wider public. Second, and this is particularly important in relation to the first decision, our submission is that contrary to the finding of the President, the second respondent has no greater authority to address the court on the public interest of media attendance at court hearings than the media itself. And indeed, there are many examples of courts ruling in favour of a media organisation's assertion of the public interest in that regard, as opposed to the assertions made by the second respondent. And by way of example, there's the Spycatcher case culminating in the decision in Sunday Times, which you have in the bundle. Third, the President wrongly directed himself to the effect that the Attorney General is the only person who's recognised by public law as being entitled to represent the public interest in a court of justice. And we see that at paragraph 64, and we also see that reasoning contained in paragraph 12 of the judgment at the bottom of page 46. But it's paragraph 64 which gives the nub of his decision. And in our submission, that's a misapplication of the Gurrier case. On its facts, the Gurrier case, which for your note is at page 55 of the authorities bundle starting at tab 7, but I don't ask you to turn it up yet. On its facts, Gurrier concerned whether a private individual could seek injunctive relief in reliance on statutory provisions which rendered the willful delay of postal packets or messages a criminal offence. And the conclusion that in the absence of the consent of the Attorney General, Mr. Gurrier was barred from pursuing the proceedings was based on an analysis of the statutory provisions in issue. And by contrast, in this context, there's no authority or statutory provision to suggest that the court may only exercise its powers to regulate open justice in this context on an application by the Attorney General. The principle in Gurrier, in our submission, had no relevance to the question of whether the media could attend the hearing of the application to seal up the will.
What does the reference to public law mean in that context of that sentence?
I'm so sorry, my lady, could you say that again?
What does the reference to public law mean in that sentence?
In the sentence I've just used?
These are not JR proceedings, it's not application for judicial review. I just wondered what he meant by public law.
The President?
Yes.
In paragraph 64. Well, he says in paragraph 64 that there's, it appears to be, he appears to be expressing it as a very general principle, that there's no role for those who might represent the media at a hearing, public or private, in putting forward any contrary view of the public interest. And we're a little unclear as to what was meant in the context of this case. Presumably it's a reference to whether the hearing had been in public or private.
Paragraph 12, he uses the same phrase. The Attorney
Yes.
General is the only person who's recognised by public law.
It may be a reference to the submissions that were made. You look at paragraphs 30 to 38.
Perhaps it's a question that can be addressed by Mr. Crowe.
Yes, and we can respond to it when we have a clearer understanding of the position. We, in understanding the submission that was made, which results in that finding in paragraph 64, have got the summary at paragraphs 30 to 38 of the judgment, and then those redacted skeleton arguments. And the skeleton argument, as you'll have seen, is very short on this point. So the unredacted part is extremely brief. The paragraphs 30 to 38 summarise the position, and it's paragraph 35 where a summary of Mr. Crowe, Queen's Counsel's submission is made. And you'll see that page 52 of the judgment, my lady, of the bundle, paragraph 35. It says, Mr. Crowe rejected the court's suggestion that allowing lawyers acting on behalf of the media to attend and make submissions might provide a proportionate process and allow additional arguments in favour of publicity to be made. He submitted that, as a matter of constitutional law, where the Attorney General represents the public interest, Gurrier, it's not possible for another party or constituency also to stand for the public interest with a contrary view. And our submission is, that submission as summarised in paragraph 35 is wrong as a matter of law, and the conclusion reached by the President in the final sentence of paragraph 64 is also wrong.
Like the apples and pears going on there. But anyway.
Yes, it does appear that a principle in a very particular other context, the Gurrier context, is then carried over and transposed to this context. And we say that's an error.
I mean, it could be a confusion between public law and public interest. Quite obviously, the Attorney General in many contexts can represent the public interest and tell the court what the attorney thinks the public interest is. It seems slightly strange to have continuous references to public law in a case that is about public interest.
Yes. We share that concern, but our core concern is that the principle as summarised in paragraph 64 is not correct. The approach adopted by the court at the first stage of the process, so the first of the two decisions that we're challenging, of course results in submissions concerning the public interest being made only by the two respondents, both in respect of the initial procedural questions about whether to consider whether or not there should be a private hearing, at a hearing from which any and all members of the press were excluded, and also, secondly, the substantive factors to consider in relation to the sealing up of the will and the time frame to be applied, i.e. 90 years. And also, it resulted in the court below only hearing submissions concerning the public interest on the wider issues about general guidance about the approach to be adopted in future in respect of the wills of other senior members of the royal family. Those submissions also only being made by the Executor and by the Attorney General. So those fundamentally important issues were determined without the court hearing submissions from the media, including my client, or indeed any other individuals or groups with particular expertise or interest in these matters, such as archivists, historians, or any others, regarding the public interest. And in our submission, that's based on an error, with the reasoning of Gurrier being understood to mean that as a matter of law, there's legally no role whatsoever for Guardian News and Media or anyone else who may wish to put forward a contrary view of the public interest to that advanced by the then Attorney General in the hearing. I'm conscious that this submission was advanced, as you'll have seen below, not by those who appear before you today for the Attorney General, but I hope if there's questions in relation to that, we can hear what they say, but what the public-private reasoning was, and we're happy to respond to it in reply.
The President is well aware, and he has sat on many cases where he's dealt with the media applications in the family context. We'll be conscious of the fact that the media can and often do make submissions in relation to what is in the public interest, the reporting of cases being an aspect of that. That's a curious way of expressing it in the judgment.
It is curious. It's a surprising and concerning sentence to see in a judgment on such a fundamentally important issue. If he meant to say something else at the end of paragraph 64, he doesn't. I mean, what he says at paragraph 64 is essentially there's a legal bar on expressing a different view about the public interest to that advanced by the Attorney General, which is not a submission or not a conclusion which can stand in our submission. Now, it's presented a little differently in the skeletons from the two respondents, which is not a surprise given the starkness of that sentence of paragraph 64, where essentially they say that, in fact, he was simply giving great weight to the Attorney General's view about the public interest. But that's not what the reasoning says. And in any event, particularly on that first question about the public interest of media attendance at court hearings, and whether the media should be entitled to be present in any form, whether at a fully public hearing or at a private hearing with accredited press representatives present, or a private hearing with delayed reporting, for example, all matters on which my client and others could have addressed the court if they were aware of the application and present. These are matters on which the media is particularly well placed to make submissions, and the Attorney General has no special role. Now, we are conscious that when it comes to the substantive decision, we do see from paragraph 34 of the judgment that significant weight is placed on the fact that the Attorney General favoured a private hearing. When you look at paragraph 35, where he notes the submission that only the Attorney General can represent the public interest, and you then read it with paragraph 64, it's clear that he approved the submission summarised at paragraph 35. Which we say was wrong. He also treated the Attorney General's view of the public interest, both of those two procedural stages, the very first decision and then the second one to proceed with a fully private hearing. He treated the Attorney General's view of the public interest as compelling and as effectively solely determinative of whether to seal up the will. We see that from paragraph 63. And we then see
Would
a
you say
paragraph...
that's wrong, that the Attorney General's view as to the public interest in this context, where traditionally the Attorney is always joined for the reason of expressing the public interest, is not compelling?
It's not. The approach that's adopted by the President is that it's solely determinative.
Well, let's
And
just
in our
assume
submission,
it's
that's wrong.
compelling. Let's just assume that what he said was that it was compelling. What do you say about that? Is that right or wrong?
Well, as a matter of principle, of course, submissions made by the Attorney General, not on the first question about whether the hearing should proceed, the hearing to consider whether or not the substantive application should be heard in private, whether that should be in private. We don't consider that the Attorney General at that initial stage has particular special expertise on the issue of the subsequent issue about the public interest in the sealing up of the will, for example. Of course, the process recognises that the Attorney General has a particular role. But when you then look at the reasoning that was advanced by the Executor and by the Attorney General, which went unchallenged because there was no alternative view, we don't accept that on the facts of this case, the submissions which were made about the public interest were in fact compelling. My Lord, my Ladies, may I just give you some other references which may be relevant on this issue, depending on the submissions that are made about it by my learned friends on this ground 3 point. So Guerrier, we say, is simply inapposite, is not an analogy which should apply here. The submission summarised in paragraph 35 and the conclusion reached in paragraph 64 are wrong in law in our submission. The comments in Guerrier about it being the exclusive right of the Attorney General to represent the public interest were in a very particular context in Guerrier about who can bring relator proceedings, that being the only issue in the case. You find that, it's tab 7, it starts at page 55 of the bundle. And you see, for example, Lord Brown Wilkinson at 101A to B, Viscount Dilhorn at 114G to H, Lord Diplock at 120 D to E, 122 D to E, and Lord Edmund Davies at 137 G. But our submission is it simply doesn't apply in this context. We have included in the bundle a number of other cases which deal with the particular role of the Attorney General and the public interest in other contexts. You have in the bundle at tab 11 the case of Blake. It starts at page 216 of the electronic bundle. And that's a case, my lord and my ladies, about a former security services agent who defected to Russia, then wrote a book about his time in the security services. The Attorney General brought proceedings in private and public law to seek to recoup the money paid to the former agent, and the claim in public law succeeded. And there is a lengthy analysis of the role of the Attorney General in giving effect to the criminal law and the public interest at pages 236 to 239, page 240G, page 241D to E. And similarly, you have the Mary Bell anonymity case, Ray X, at tab 14, page 266, where the claimant sought a contra mundum anonymity injunction 35 years after killing 2 small children when she was aged 11. 2 major newspaper groups named as defendants didn't oppose the application, and they didn't represent the media generally. And as a result, the Attorney General was invited to intervene to advise the court on the issues of public interest. See that at paragraph 2, page 269. Of course, there's no suggestion in that case that only the Attorney General could speak on the public interest, or indeed that the Attorney General's view of the case was solely decisive. Indeed, then President Butler-Sloss took into account the absence of objection of the media when granting the application. And in Binyam Mohammed, which you have at tab 17, page 348, paragraph 96, in that case, the allegations of torture had been referred to the Attorney General for investigation. You'll recall that was a reason why the Divisional Court didn't order the reinstatement of paragraphs in respect of public interest immunity, PII. But the Divisional Court still sought submissions from the media on the point of whether the paragraph should be reinstated, and that goes, return to that when we deal with the issue of fairness, procedural fairness, and the importance for the media. And finally, just as a reference on this issue about the role of the Attorney General in this particular context, may we also refer you to tab 29, page 635, paragraphs 54 to 55. And that's in the Sunday Times case. And you'll see at paragraphs 54 and 55, page 635, that Strasbourg overruled the Attorney General's assessment of necessity in the context of Article 10 in that case. So on ground 3, our position is a simple one, and we agree with you, my lady, that that passage, paragraph 64, the sentence is a curious one, and it's a concerning one. And in our submission, it was an error in law when the President directed himself that only the Attorney General could speak as a matter of public law as to the public interest on those initial procedural decisions and ultimately on the substantive issues arising in the appeal. I intend to turn back to ground 1, and my lord, I hope it was helpful to deal with ground 3 out of order, given the indication you had at the outset. So in respect of ground 1, fairness, our submission is that the President erred in law in denying the media, including Guardian News and Media, an opportunity to make submissions on the issue of whether the hearing of the application to seal up the will should proceed in private and with all press representatives excluded. Now, plainly, as we see from the judgment, his initial instinct and his initial provisional view was different. And he had intended to put the media on notice, but he was persuaded to take a contrary course, as is reflected in the judgment, by the two respondents, who were in agreement that the entire matter should proceed as a private hearing, and that even this first initial decision should proceed without any input from the media in the form of attendance at the hearing, notice of the draft order, written submissions, submissions subject to undertakings. Simply the approach that was taken was that the decision should be made without the media being present and without the media being on notice. Now, our submission, we've summarised in paragraph 28 of our skeleton the three underpinning principles, and I'll turn to those and then address you in some of the case law in support of our position. So we make three core points. First, an order excluding the media from a hearing is a serious interference with both the common law principle of open justice and with the rights of the media and indeed the wider public pursuant to Article 10, on the basis that the media acts as the public's eyes and ears. So those principles in the cases I referred to earlier about the central importance of open justice and the role of the media under Article 10 do apply, we say, without modification as a matter of principle in this context. This is not a context in which there is an alternative approach adopted in primary legislation, and the submission we make is that excluding the media from the hearing is a serious interference with both common law principle of open justice and Article 10 rights. Second, where a party, in this case the Executor, supported by the Attorney General, seeks an order that interferes with open justice at common law or interferes with the rights of the media under Article 10, in our submission, and I'll return to the cases which make this good, it's well established that the media has a right to make submissions in respect of such an application, and also that the media has a right to make meaningful and effective representations.
Does that apply in every case in which a hearing is held in private? I mean, in many cases, briefing injunctions, all that sort of thing.
Well, there are a series of cases which deal with sometimes there being intense urgency.
I mean, there are obviously there's a line of authority dealing with what originally were the super injunction cases, where the court developed a practice so that the media, if directly affected by the order the court made at the hearing held in private, and indeed under the Human Rights Act, the media party affected maybe have to be notified.
Yes.
But your submission seems to be broader than that, and that in any case in which the court is contemplating having a hearing in private, it cannot lawfully do that unless it invites representations from the media as to whether that is a proper cause.
So it's quite right that there's a range of contexts in which a well-trodden process has now been developed, the super injunction cases being one, reporting restriction orders in the family division being another. Our first submission under this heading is, as a matter of principle, that where an order is sought which interferes with open justice, interferes with Article 10, the media does have a right to make submissions.
So what's the authority for that proposition?
Yes, I was going to come to those just after setting out the principles. May I just finish setting out the principles, then I'll turn to the case law. It may just save us some time.
Well, I mean, the thing that you need to deal with is the submission on the other side, that it's completely misconceived to say that there is a right in the media to make submissions in every kind of litigation about openness of a hearing. And if you look at 39.2, that doesn't support it.
I mean, for example, in the there are rules which deal with it, and the practice direction from the then Master of the Rolls in relation to superinjunction set out a procedure, but it applied to a specific category of cases. So the contrary argument might be that since it defines there are cases where the media is identified as having a right in that way, it doesn't follow that it has a right in every case.
It's the point that's made against us, I was going to come to this, the point that's made against us is that we can't ground a fairness argument because there isn't an automatic right to be heard. And in our submission, that's incorrect. And we see that clearly from the cases, where there's a range of cases in which the media have no automatic entitlement to be heard. There's no statutory provision determining that they should be heard and so on. But nevertheless, as a matter of procedural fairness, it's accepted that there's an interference with common law principle of open justice and or Article 10 rights, and so there's a procedural entitlement for them to make submissions and to be heard.
It's one thing to say that the court, when considering whether to sit in private, must consider these factors. Quite another thing to say that before it does so, it must invite, in every case, which is how your submission is framed, including in your skeleton argument, in every case, it must, as it were, press the pause button and invite presentations and query, if so, from whom, in circumstances where the media is rather an amorphous concept. I mean, who represents the interests of the media in these circumstances? To whom, for example, should notification, and if so, on what basis? When you have the injunction alerts system, which has been set out by the media itself, it used to be called something else. I can't remember what it's called now. What it was called before.
Copy direct.
Copy direct. But that, again, in itself related only to a defined category of case.
Well, here we're dealing with accredited journalists.
And what are they?
So,
I mean, I only ask the question because I'm not aware that there's any definition of an accredited journalist.
so they hold a press card. So this is different to, for example, bloggers. So it's the same definition that's applied in the family division, for example, in relation to accredited press representatives being in attendance, or indeed in a range of other contexts, including the coroner's courts, when you have accredited members of the press in attendance and live tweeting, for example.
But you know, you say there's a right, and the word right is incredibly important. And if there is a right, then it must be grounded in either statute or authority.
So, my lord, this is a straw man which has been set up by the respondents in relation to there being no enforceable right. The submission which we make, which we've made carefully at paragraph 28 of our skeleton, is that an order excluding the media from a hearing is a serious interference with the common law principle of open justice and with the rights of the media pursuant to Article 10.
Yes, but
so
it's,
that's a
the
different
right is
thing
not
to
founded on Article 10, Ms. Gallagher, because Article 10 doesn't say that. So your B is what I'm querying, which says in terms that where a party seeks an order that interferes with open justice or the rights of the media under Article 10, it is well established that the media has the right to make submissions. Right? Now, you can say that, but I need to know where it is well established.
Of course. So I'll take you to the key cases.
In a case of this kind.
Yes, well, there isn't a case in a case of this kind. For the reasons we've discussed earlier, this is new ground.
By analogy, then.
But I am going to take you to Binyan Mohammed and the BBC case and various claimants to those cases in a moment. And also I'm going to refer by analogy to the practice direction on interim non-disclosure orders. I'll do that in a moment. Just to summarise the position that we have on this issue. My lady asked a question about an entitlement to make submissions in advance in every case. And I'm going to take you to the passage in A in the BBC, which refers to ideally those affected being notified in advance, but there being some circumstances in which that may simply not be possible. And this particular case there was no time sensitivity requiring that the hearing must proceed without advance notice. As it happens, everything happened, as we understand it, on the 28th of July. So on the 28th of July, from what we can understand from the judgment, the President said, I'm minded to notify the media. He's persuaded not to notify the media of his, by the two respondents. And then everything appears to have been decided on the same day. Both that very initial decision to proceed to consider whether or not a substantive hearing should be heard in private, that very initial decision is made on the 28th of July at the hearing, it appears to us from what we've seen. He then proceeds to consider whether it should be heard in private. He then proceeds to consider the substantive application. And we see from the judgment the hearing is 28th of July. There then is a reference to further written submissions being invited in relation to the process to be followed in respect of unsealing at a later stage. And then the judgment is handed down on the 16th of September. There was no particular time sensitivity, which meant that the media couldn't, in this case, have been put on notice, for example, in advance with a copy of the draft order, and a copy of the application, or be put on notice on the 28th of July. As we've set out in paragraph 28, our submission, and then I'll turn to the cases, is that the President breached the standards of procedural fairness at common law and under Article 10 by denying the media the opportunity to make such submissions before deciding to hear the application to seal up the will in private without any press representatives present. And not only were the media not informed that such an application was being made, or that the hearing was going to take place, there was no public listing, going to one of the questions earlier, or even a private notification of the listing. They also weren't provided with any of the materials relied on in support of the application for a private hearing, such as the submissions, which we subsequently received in October, subject to undertakings, or indeed the draft order, which was sought, which we still don't have. And the result of this is that Guardian News and Media and other media organisations were denied the opportunity at all, still less any effective opportunity, to make submissions about this serious interference with their rights under Article 10 and with the open justice principle. And they were denied any opportunity to seek the recall of the order promptly at a hearing inter partes before their interests had effectively been shut out, because the first they heard of it was 16th of September, when it was all a done deal and the entire process had been decided without them having any input. So may I then take you to a number of the authorities on this point. So first, in the authorities bundle, you've been provided a tab 4, starting at page 8 of the bundle, with the extract from the White Book of CPR 39.2, which doesn't directly apply. There appears to be agreement that the principles are helpful by analogy, and the White Book commentary on that. And I ask you to turn to that because of 39.2.5. So 39.2, general ruling, hearing to be in public. 39.2.1, general rule is that a hearing is to be in public. Hearing may not be held in private, irrespective of the party's consent, unless and to the extent that the court decides that it must be held in private, applying the provisions of paragraph 3, and you then have the test set out in paragraph 3. Hearing or any part of it must be held in private if and only to the extent that the court is satisfied that one or more of those matters in A to G applies, and that it's necessary to sit in private to secure the proper administration of justice. And then 39.2.5 states, unless and to the extent that the court otherwise directs, where the court acts under paragraph 3, as relevant here, a copy of the court's order shall be published on the website of the Judiciary of England and Wales. Any person who's not a party to the proceedings may apply to attend the hearing and make submissions, or apply to set aside or vary the order. And the commentary on 39.2.5 starts at page 15 and runs on to page 16 of the authorities bundle. It's the very bottom of page 15 of the authorities bundle, describing 3925 as a new procedural mechanism for determining open justice issues. The procedure allows media organisations or other potential opponents of anonymity orders to be notified of such orders being made, and the procedure adopts a similar approach to that set out in the practice direction on committal for contempt. And you'll see it then says 3925 covers those situations where the court has decided to hear case in private and where the identities of the parties are anonymised. The court is placed under a positive duty to make the orders public by following a simple procedure which will result in an electronic copy of the order being made available on the relevant website, and a non-party is thereby able to challenge the order by making an application to the court. And reference, of course, is made to, in many cases, the court directing the order shouldn't be published or not served without safeguards such as anonymity or redactions.
So it makes no reference to any right of the media to be heard.
No, it doesn't. It refers to it being a mechanism in recognition of open justice principles to enable media or other opponents to be notified so that they can...
Completely different mechanism from notifying the media before you decide the question.
My Lord, I'm sorry, I don't quite follow the question.
Well, your case is that there is a right of the media to make submissions in respect of an application that will interfere with open justice. Therefore, it follows from that submission that the media is entitled to be notified before the question is decided. Part 39.2 says that the media is entitled to be notified by publishing on the website the order that's made so that it can apply.
Yes, but here, of course, there was no notification at a sufficiently early stage. I'm going to take you to the cases. I mentioned Binyam Mohammed, which is at tab 17, starting at page 316.
At some point, could you address the applicability of Article 6?
Yes, my lady. In what particular respect would you be assisted by submissions on Article 6?
Whether Article 6, which is foundational in some of these cases, applies to the sort of application which is being dealt with here.
So the Article 6 interests of the media, is that the...
No, well, it's the provisions of Article 6 of the ECHR.
In respect of the parties to the proceedings or in respect of the media?
Well, just generally.
I'm happy to do
because
that
that's
after lunch.
part of the aspect of openness which is addressed in some of the authorities.
I'm very happy to pick that up after lunch, my lady. I just want to ensure that I've understood the question correctly. So in Binyam Mohammed, the Divisional Court expressly sought submissions from the media on whether paragraphs from its first judgment
Well, this is going to take a bit of time, isn't it? And it's now 1 o'clock.
Yes,
so
I can address this after lunch.
Okay. Well, we'll resume at